Hello, everyone. Thank you for joining us today. My name is David Fullmer, and this is Richard Yemm. We're both attorneys and partners at WR Immigration in Santa Monica. And our topic today is something that's very timely. It is H-1B alternatives and strategies for corporate immigration problems to deal with foreign national employees who were not selected in the upcoming lottery. One thing that we do know about this year's lottery system is that in order to eliminate the possibility of duplicate selections, there will be a beneficiary-centric system. So the chances of selection are not as low as they were last year, but realistically, the chances of any given foreign national employee being selected is not high. So now is the time to closely look at each foreign national employee to determine if there are any alternatives to the H-1B in the event that they're not selected. Now, Richard, starting off, a question that comes up from a lot of corporate immigration programs is whether or not there will be multiple rounds of selections in this year's upcoming lottery like there were last year and the year before. What do you think about that?
I think it's a great question. Happy Friday, everyone, by the way. But the issue here is there is precedent for multiple drawings. I think back in 2021, there were actually three drawings. They had one in March, one in July, one in November. Fiscal year 2023, which is in 2022, it was a one and done year. They had one drawing. That was all that you got. Last year was a bit of an anomaly, I think. The registrations, like you mentioned, I think eligible registrations increased by about 60% last year. But still, they did have two drawings. They had one in March, one in July. I honestly think a lot of that was due to this multiple, beneficiaries with multiple eligible registrations. I think there was a
Right.
lot of employees who had multiple different employers file for them, and maybe they got selected two or three times, but they're only going to use one of those. So I think that led to immigration kind of saying, okay, we need another drawing just to make sure we hit the cap, the quota. My prediction for this year, I mean, look, I live in hope. I'm always trying to be an optimist, but I think there's only going to be one drawing. I think it's going to be less this year with this beneficiary-centric model that you've been talking about. I just think that most people who are selected are going to move forward with their case.
I think so too. I think that the likelihood of being selected will be higher and only one round of selection. Rich, is there any way to obtain an H-1B visa without going through the lottery and being selected in the lottery? Are there any workarounds there?
Yeah, I mean, there is something called a cap exempt employer, right? Which would be someone who can file an H-1B at any time of the year. They don't have to go through the lottery, don't have to worry about the registration. But to be honest, those employers are probably not watching us today because they don't have a problem with the H-1B lottery. So you might ask, well, how does that impact me if I'm a cap subject employer? Well, remember that the H-1B, you can have concurrent H-1Bs. So you could have an H-1B with one employer and another employer. There's a bit of a loophole where if an employee is working for a cap exempt employer, they are allowed to, at the same time, concurrently work for a cap subject employer. Now, there's limitations there, because if for some reason the cap exempt employment ends, then you're a cap subject. You're no longer eligible to work for the cap subject employer. But, it can be an option. And we've seen a few situations where a company has some kind of a relationship, affiliation with a cap exempt employer. Maybe the employee can work, part-time with the other company. And then that by working with them, that allows them to continue working with the cap subject employer.
That's a great idea, Rich. So what about the idea of the employer sending an employee who's not selected in the lottery, sending them abroad to work for a period of time? Is that ever a viable strategy? And how could they ever come back to the US?
It's definitely a viable strategy, particularly if you're a larger corporation that has multiple offices abroad, particularly if you have offices in Canada, because then you could potentially send an employee to Canada and then they're at least working on the same time zones, this kind of thing. It just makes things a lot easier. The problem, I think, sometimes is getting the buy-in from the employee because the employee might not really want to go abroad. They want to be here.
Right.
having to go abroad for 12 months isn't the ideal situation, but we've spoken with HR teams before, where they want to really keep this person. And sometimes the way to get buy-in is basically say, look, we can try for an H-1B next year, but if you're sitting in April and you weren't selected, you could be looking at 12 months before you have a chance of being selected in the next lottery, and then 18 months from that day, from the current day, before you could actually start working on an H-1B. So when you start to factor that in and look at, that potential time frame, 12 months doesn't sound quite as long. Plus, there's the fact that when the person comes back to the US, that can also open up opportunity to file for an EB-1C, which is a green card for those managerial employees. But the key with the L1, they've got to work full time, they've got to work in an affiliated company abroad, and it has to have been in a managerial or executive level position. And immigration can be pretty tough on those cases. So it's not always the easiest option, easiest alternative there.
They are pretty tough. Seems like RFEs are very common with L1 cases these days.
For sure. Yeah.
Rich, what if going abroad is not an option? Are there any other regular work visas that employers should look at?
Yeah, so I love the O1 visa. It doesn't work for everyone. This is the O1 extraordinary ability visa. Otherwise, people sometimes call it the Einstein visa, this kind of thing. The key here is that, yes, if you have some Nobel Peace Prize or something like that, you can get an O1 relatively straightforward. But most people don't. And there's about 8 or 9 criteria. You have to just show you qualify under at least 3 of them. So, it's something. The criteria can include things like lead or critical role for a distinguished organization, maybe sitting on a panel to judge the work of others, maybe getting some press, maybe doing scholarly articles. Like there are things that you can do. And I feel like, I've spoken with HR teams where, again, they really don't want to lose this person. They don't like the fact that the H-1B, it's a lottery. It's just down to chance. You just basically got to cross your fingers and hope. At least with the O1, there's a bit of an element of control there. If maybe the employer can, put the person front and center when there's a big success or something like that, there are options that can potentially lead to an O1 down the line. And the O1 you can file anytime. You don't have to worry about a cap or a quota. So it's definitely, I like it as an option. It's outside the box, doesn't work for everyone, but I think it's worth looking at.
That's a very good point. There are also 2 types of O1s. There's O1A and O1B. B for the artists, and I've had some success doing O1Bs for people that are working in graphic design and marketing within a company, and the standard is a little bit lower, and they're a little bit easier than the O1As.
Yeah, and the O1B also works for those in motion picture and TV industry. So even if they're not necessarily artists, it can work for producer types and this kind of thing if they're involved in that industry, which being in LA, we see a lot of people working in that kind of field. But David, do you want to speak about some options that might be available for nationals of specific countries?
Definitely. The U.S. has free trade agreements with 5 countries. And so if your employees who are not selected in the lottery are nationals of one of these lucky 5 countries, then they can pretty easily obtain a visa that would work quite a lot alike an H-1B without having to go through the lottery. And the 5 countries are Canada, Mexico, Australia, Singapore, and Chile. The visas are TN visas for citizens of Canada and Mexico, E3 visas for citizens of Australia, H-1B1s for Singapore and Chile. That's different than H-1B. It's H-1B1. So some of the benefits of these are, in addition to not needing to go through the lottery, these visas can be filed directly at the U.S. consulates, although it's possible to file a change of status in the U.S. It's not necessary to file an I-129, and employers can avoid that $2,800 premium processing filing fee. So these can be great options. First of all, for the TN visas for Canada and Mexico, they're only available for the 60 or so occupations listed in the free trade agreement. But they do list on the free trade agreement list, there's a lot of professional occupations that would be on the H-1B list, like lawyers, accountants, teachers, engineers, computer professionals, can be included, like software engineers and computer systems analysts. Canadians can obtain a 3-year visa right at the land border or the airport. So they don't even have to go to a U.S. consulate or file with the USCIS. They can apply directly at the land border or airport, and so it's pretty quick. Mexicans can obtain 4-year visas that they have to apply directly at the U.S. consulate. And this H-1B1 visa for people from Singapore and Chile and the E3 is quite similar to the H-1B in that any job that fits into the definition of specialty occupation can be applied for. You still have to do an LCA, but you can again apply directly at the U.S. consulate. So for people from one of those 5 countries, they're very lucky, and you should be able to keep those employees without having to go through the H-1B lottery.
And speaking of countries that have treaties with the U.S., I mean, the E2 or even the E1, there's the treaty trader, treaty investor visa. Is that ever an option? Is that something that people could use?
I think it would be rare, but in certain situations, it's extremely beneficial. Talking about the E2, the U.S. has E2 treaties with about 80 countries throughout the world. So if there's a couple hundred countries, the U.S. has treaties with a significant amount of those countries. And if your company is majority owned by citizens of a treaty country, or if it's a subsidiary of a publicly traded company traded on the stock exchange of a treaty country, then an E2 visa might be available for citizens of that country. So an example would be a Japanese automaker might have a subsidiary in the United States, and they're probably getting E2s for most of their Japanese employees, and they're probably using H-1Bs for their non-Japanese workers. So E2s are a great tool. If your company is qualified for E2, it probably knows already, but some companies don't. Sometimes it can be a great workaround.
Yeah, I've definitely seen situations where the E2 can be used, but like you said, it's normally something that they would already have explored and maybe used it for those nationals. But aren't there some situations where an employee might be eligible for work authorization based on, being married to someone who's on a different kind of work visa that allows their spouse to work?
That's a great point, Rich. And this is something that really should not be overlooked. Spouses of some categories can get work authorization. For example, the biggest example is that spouses of H-1B workers who have approved I-140s can obtain what's called an H-4 EAD. And there's 2 ways to get into H-4 status. The person can either file a change of status within the United States or obtain the visa at the U.S. consulate, which is sometimes a little bit quicker. And then after they get into H-4 status, they have to file Form I-765 to get the EAD card, and then they're work authorized. And then spouses of L1 holders and spouses of E2 holders are also automatically authorized to work in L1S or E2 status. So it's automatic. They do not need to obtain an EAD card. But even if your employee gets one of these H4 EADs or L1S or E2S, I still recommend that you as a company enter them into the lottery each year, because you don't want your valuable employee's ability to continue to work to be dependent on whether or not their spouse has a job. So you want to keep on putting them into the lottery every year until you get them onto an H-1B, where then you as a company are in control of whether or not they can work.
Absolutely. I think that's really good advice. But okay, so what if an employee is on STEM OPT, for example, where they've got, 3 years, they have some time to play with? Couldn't the employer just go straight for a green card? Maybe just, bypass the whole non-immigrant visa and just jump straight into getting permanent residence?
I wouldn't recommend that they bypass the H-1B. I would recommend, first of all, that if you have one of these employees who has a 3-year runway, first of all, you should put them into the H-1B lottery every year. And sometimes companies identify people when they're not quite graduated yet. So this time of year, they found people, they know they're going to hire them when they graduate. Companies should put them into the H-1B lottery every year. So they have maybe 4 chances at the lottery. But at the same time, if the employee is not from one of the countries with severely backlogged priority dates, which is, of course, India and China, there may be time to do an EB2 or EB3 perm, get an I-140 approved, and get an EAD based on a pending adjustment of status before that 3 years runs out. So it could be a very viable option. The timing is not certain. So again, you want to put the person into the lottery every year. And since we're talking about green cards, Rich, you're an expert in national interest waivers and EB1 cases. Would these be a viable alternative and kind of circumvent the need to do a whole perm labor certification?
It's possible. I mean, particularly national interest waiver. Again, if you mentioned if you're not from one of the countries that's particularly backlogged. I mean, I think our firm has seen a 200% increase in national interest waiver cases. Immigration seems to be, so far being pretty good with those cases. Particularly if you're in AI in these kind of fields or anything that's kind of where there's a scope for national interest benefit in terms of what you're doing. So, I mean, that definitely can be an option. You can file for it. You can actually, the employee themselves can actually file for it themselves. So, all the fees can be paid by the employee on that. Similar to the O1, there's also an EB1A, which is extraordinary ability. It's a much higher standard, but it's another option. If you are in a situation where you're very accomplished, you've got a lot of different things going for you, it could be worth exploring these options as, just a way to jump straight to the green card, particularly if you do have a long time. But you've always got to be careful because when you're on STEM OPT, you're on a student visa, it's a very temporary visa. You have to make sure you're good with the timing when it comes to, are you filing for an immigrant petition? Are you demonstrating immigrant intent? That side of things. But yeah, definitely another option. I guess we've kind of gone through a lot of the alternatives that are available for HR teams today. We're probably running a little bit short on time, but David, did you have anything additional you wanted to add? Any other options?
A J1 visa as a trainee is sometimes an option for certain individuals. Now, again, this is a trainee visa, so it's not ideal for somebody who's already finished 3 years of training on their OPT and STEM OPT. But if you've got an individual who's overseas, who has at least a bachelor's degree or 5 years experience in a job that's related to position in the United States, then the J1 visa as a trainee might be an option. One thing that you do have to be careful with J1s, they're only valid for 18 months, and individuals from certain countries might become subject to a 2-year home residency requirement where they have to actually go back to their home country for 2 years before they can get an H-1B or a green card. So J1s are something that you might look at, and there are a few other categories too, but I think that J1 is probably the one that's most important that we haven't touched on yet.
Sounds good. Well, I think that's about all the time we have for today. Apologies for any technical issues before. Thanks so much for joining us. If you do have any questions, feel free to drop them in the comments below, or you can message myself or David directly, and we'll be more than happy to assist. But thanks so much for joining us.
Thank you.